In this video, I will be talking about adjudication, prosecutions, offences and penalties. Before getting on to the video, if you have still not subscribed to our channel, please subscribe. If you like this video, please press the like button and then share it to your friends. We learnt about basically some of the important terminologies under Companies Act 2013 relating to adjudication process as well as adjudicatory authority. The one of the important aspects which is being involved or the formal way of basically corporate actions, whereas if a ministry or if any regulatory authority or the regulatory actions which has to take place, the formal way of expressing it, it will be called as adjudication. So, adjudication is defined to mean a formal process of ascertainment of non-compliances of law and imposing penalty. We have seen some of the important procedures which will happen or what are the important phases which is involved in the regulatory actions. Like basically it might be inspection, inquiry, and then basically penalty. If there is any punishment which is required to be given, there is a requirement to even by way of sentencing to the imprisonment, all that would fall under the category of punishment. Please note the adjudication process as well as the prosecution process. Please note adjudication versus prosecution. Adjudication results in prosecution if we involve the provisions of Code of Criminal Procedure. Please note there are two important procedures involved here. If it is only levying penalty, the penalty is in the form of only fine. Under those circumstances it will be considered as civil nature. And if there is fine and imprisonment or it is only imprisonment, those are the important circumstances where we will consider it the adjudication process has to happen according to the Code of Criminal Procedure and that will end up in prosecution. Okay. So, basically if you look at under the provisions of Companies Act 2013 or any other law for the time being in force and it is applicable to a corporate person, it is really important for us to come to the conclusion what is the type of penalty for the default it will be imposed. If the penalty is fine or imprisonment, only fine or imprisonment, then it will be necessarily called coming under the bracket of civil nature. If it says only imprisonment or fine and imprisonment, under those circumstances it would fall under the category of criminal adjudication. So, basically like we have two types of courts which is being set up as per the provisions of Companies Act 2013. You have National Company Law Tribunal as well as special courts. National Company Law Tribunal is a civil court. So, the adjudications generally like if you have any aggraved by the orders of the adjudicating authority, whether it might be registrar of companies or it might be regional director or it might be central government, the appeal against the adjudication related to civil nature will lie against National Company Law Tribunal, whereas any prosecutions which is being arising out of adjudication where imprisonment is required to be done or if there is any the Code of Criminal Procedure is involved, then special courts will have the jurisdiction. So, if you look at in case of civil, the first important activity will be ascertaining the default. If a default basically like it can be ascertained either suo moto, that means a person who has committed a default can ascertain himself that he has committed the default and the act prescribes what is the penalty which is required to be paid for the default. Take for example, the company was supposed to conduct the annual general meeting within 30th of September. The company was not able to conduct the annual general meeting within 30th of September because of various reasons. Instead, it postponed the the activity of holding the annual general meeting to the month of December. There is a possibility they could have asked for extension for holding the annual general meeting from the registrar of companies, but they did not do it. But they extended it and then they held it in the month of December. Now the default is already aware to the board of directors of the company. To make that good, the default which is being already conducted, the penalty is required to be paid. Please note there are two options available with me. One is to wait till the adjudicatory authorities identify my default and then levy penalty, or I can compound it. Compounding is one of the important terminology where the default is already known I am going to settle that particular default by way of making the payment of penalty. In case of the civil nature, if the dispute or if there is any default which is arising out of civil nature, then all these possibilities are available. When it comes to the offences which is of which is punishable with imprisonment, and then basically which is governed under the criminal procedure, then fine or imprisonment or both if it is there, then definitely those type of offences are non-compoundable, and then there will be a prosecution before the criminal court. So, how exactly the process of adjudication happen? What are the steps involved in the process of adjudication? What is the role of company secretary in each and every stages of adjudication? How the company secretary has to actively participate in the process of adjudication? All that we have to necessarily study under this particular chapter. Before concluding, there is one more important thing which we need to necessarily understand. In case of company law, there are a lot of attempts which is being made to decriminalize the offences, to ensure that the potential non-compliances which is arising out of company law defaults should be of civil nature. Only the most serious ones should end up in the criminal nature. That is what is the basic intention of the government. In that sense, to understand the fundamental principles which is being underlying between the the penalties which is being levied as per the provisions of the law, in case of company law, majority of the offences are non-cognizable ones. That means they are of civil nature. Non-cognizable offences are basically, even under the fundamentals of criminal law, they are bailable in nature. So, if an arrest is required to be done to a person, without warrant arrest cannot be done, whereas cognizable offences are very serious in nature, like murder, or it might be the imprisonment of more than 2 years, 3 years. These all are the circumstances where it will be non-bailable in nature, arrest can be made without warrant. Like in company law, majority of the instances are non-cognizable offences itself. So, for professionals, it is really important that how the adjudication process works, and they should necessarily understand what is their role when the process of adjudication is going on. If you want to learn more about this particular course, please fill up the Google form which is being provided in the description box below. If you have any questions associated to this particular video, please comment. If you want to know more about the courses offered by Ekcel Academy, please visit our website www.excelacademy.com. Thank you.